Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law Number 2. You have been asked to come to court today because you have a case in County Court at Law Number 2. The case that you have is a criminal case. Criminal cases are divided into felonies or misdemeanors. If you had a misdemeanor case, well, your misdemeanor case are normally referred to as your petty offenses. And your felony cases are normally referred to as your serious offenses. Does not, the reason why they are considered serious is because of the punishment range and the nature of the offense. Now, the case that you have in this court is a misdemeanor case. Now, felony cases are divided into 5 categories. Misdemeanors are divided into 3 categories. If you had a felony case, the felony cases are classified either as a capital murder, first-degree felony, second-degree felony, third-degree felony, or a state jail felony. If you're convicted of a state jail felony, the range of punishment is minimum 6 months in the state jail to a maximum of 2 years, a fine up to $10,000. If you're convicted of a third-degree felony, the range of punishment minimum 2 years to a maximum of 10 years, fine up to $10,000. If you're convicted of a second-degree felony, the range of punishment is minimum 2 years to a maximum of 20 years, fine up to $10,000. If you're convicted of a first-degree felony, the range of punishment is minimum 5 years to a maximum of life in the state penitentiary, now, or 99 years to life. Now, if you are convicted of a capital murder, the range of punishment is life without parole or death by lethal injection. Now, as I mentioned earlier, the case that you have is not a felony case, so you don't have to worry about the felony punishments. Misdemeanor cases are divided into 3 categories. You have the Class A misdemeanor, Class B misdemeanor, Class C misdemeanor. If you had a Class C misdemeanor, and I think somebody does have a Class C misdemeanor, the range of punishment is by fine only. Now, your Class C misdemeanors are cases that are normally handled in the city court or the JP court, and then they are appealed to this court, the County Court at Law. And as I mentioned earlier, if you are convicted of a Class C misdemeanor, the range of punishment is by fine only. In essence, we cannot give you jail time for a Class C misdemeanor. However, if you are given probation or if you fail to pay your fine, we can convert it to community service. And if you fail to pay your community service, we could issue what is called a capious pro fine. That basically means we could issue a warrant for your arrest for failure to pay the fine or perform the community service, and you'll be required to either pay the full amount of the fine or sit out the jail time in the county jail. Now, if you had a Class B misdemeanor, the range of punishment minimum 0 days to maximum of 180 days, which is 6 months in the county jail, a fine from $0 to $2,000 or anywhere in between. Or you could be given both such fine and confinement. If you're convicted of a Class A misdemeanor, the range of punishment is 0 days to 365 days, which is a year in the county jail, a fine from $0 to $4,000, or you could be given both such fine and confinement. Now, the paperwork that you have in your hand, I'm going to go over that paperwork with you. The first document that you have is titled Judge's Explanation of Rights to Defendants Without an Attorney. Now, that document talks about one of the rights that you have. You have a right to have an attorney. And as a defendant in a criminal case, regarding your right to have an attorney, you have 3 options, as stated in that document. Number 1, you may hire an attorney. Number 2, if you do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you. Or number 3, you may represent yourself. If you want an attorney to represent you and you have enough money to hire an attorney, the case will be reset, meaning that you'll be given another court date to give you time to hire your attorney. If you want an attorney and do not have the money to hire one, you will need to fill out a financial questionnaire. Now, that financial questionnaire should be included in your paperwork. The financial questionnaire is titled Jefferson County Affidavit of Indigence. You would have to fill out that form so that the proper person can determine whether or not to appoint an attorney to represent you. Now, if you want to represent yourself, you may not represent yourself unless you cannot speak to the prosecutor unless you sign a written waiver of your right to be represented by an attorney. Now, the prosecutor is an assistant district attorney. We have one here. It's Erica Porter. And she will be able to talk to anyone who is waiving their right to attorney and would like to represent themselves. Now, be aware that there are dangers to self-representation. Waiving your right to attorney and representing yourself may result in a worse outcome for you and your case, including loss of significant legal rights, including military service, possession of a firearm, housing and public benefits, immigration status for non-citizens, and employment. That last sentence states, if you choose to proceed without an attorney, that is, if you decided that you wanted to represent yourself, you may change your mind at any time, and you may request an attorney be appointed to represent you. Now, at the bottom of that document, in bold letters, it states, defendant's choice. Mark initials next to only one choice. If you choose to hire an attorney, then you will place your initials on the first line to the left, and your case will be reset to give you time to hire an attorney. If you have already hired an attorney to represent you in your case, then place your initials on the second line to the left and the name of the attorney on the line to the right. If you choose to apply for a court-appointed attorney, then you will place your initials on the third line to the left. If you have already been appointed a court-appointed attorney, then you will place your initials on the fourth line to the left and the name of the attorney on the line to the right. Now, if you choose to waive your right to an attorney, that is, to give up your right to have an attorney to represent you, and you desire to represent yourself, then you will place your initials on the fifth line to the left. Now, once you have finished initialing one of the 5 lines, then you will sign your name on the line that is titled defendant, and you will date it today's date, July 18th of 2023. Now, for those of you who will be waiving your right to an attorney or giving up your right to an attorney, and you will be representing yourself, the second document that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial, you'll have to read that document, and then if you agree, you will sign that document. And the document states as follows: I have been advised of the nature and charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily and intelligently made. Furthermore, I have been advised this 18th day of July of 2023 by the County Court at Law number 2 of my right to representation by counsel in the case pending against me. I have been further advised that if I am unable to afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed to me free of charge if I am not financially able to employ counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel. Waive means give up. So I hereby give up my right to have an attorney. If that is your choice, then you will sign on the line that is titled defendant, and you will date it today's date, July 18th, 2023. Now, as a defendant in a criminal case, you have other rights as well. One other right that you have is a right to have a trial by jury. And what I mean by right to have a trial by jury, you have a right to have a jury to listen to the evidence in your case. And the jury actually will sit in that area where those young people are sitting, and they will decide after listening to all the evidence whether or not you are guilty or not guilty. You also have a right to waive your right to have a trial by jury or give up your right to have a trial by jury. And by doing so, your case will come before the court or the judge in one of 3 ways. One way it can come before the judge is by way of a bench trial. A bench trial means that you will not have a jury trial, you will have a trial before the judge, and the judge will listen to the evidence, and the judge will decide after listening to all of the evidence whether or not you're guilty or not guilty. The other way that your case will come before the court is by way of an agreed plea bargain agreement. What an agreed plea bargain agreement is, it's an agreement that you have reached with the state to settle your case. And then if you've reached a plea bargain agreement with the state, then that agreement will come before the judge, and the judge can either accept or reject the plea bargain agreement. So for example, let's say you and the state have talked and the state say, well, I'm going to offer probation in the case. And it comes before the court and the judge say, well, I'm not going to follow that plea bargain agreement. If the judge does not follow your plea bargain agreement that you have reached with the state, then you have a right to withdraw or take back your plea, okay? Now, if the judge does follow the plea bargain agreement, and if you decide within 30 days that you would like to file an appeal, what an appeal is, it means that you want a higher court to review your case because you think that either you've been wrongfully convicted or this court has committed an error by convicting you. And if that's the case, in order to file the appeal, you have to get permission from the judge who followed the plea bargain agreement. If the judge gives you permission to appeal your case, then your case will go upstairs to the Ninth Court of Appeals, which is located on the 3rd floor. And the Ninth Court of Appeals could either grant or deny your appeal. If they grant your appeal, they could just simply find you not guilty, or they could send the case back down to this court and order this court to give you a whole new trial. If they deny your appeal, then at that point, you can appeal it to a higher court than the Ninth Court of Appeals. You can appeal it to the highest court or the highest criminal court in the state of Texas, which is the Texas Court of Criminal Appeals. Now, you would have to file what is called a pro se petition for discretionary review. That simply means that pro se means that you will not be represented by an attorney. You'll be filing this petition on your own, pro se. And the Texas Court of Criminal Appeals could either either grant or deny your appeal, your petition. Now, if they grant your petition, then they can simply find you not guilty, or they can send the case back down to the Ninth Court of Appeals, or they can send it back down to this court and order this court to give you a whole new trial. If they deny your pro se petition at that point, then your conviction will stand. Now, the other way, the third way that your case can come before the court is by way of an unagreed plea bargain agreement. What that simply means is that you and the state have not been able to reach an agreement to settle your case. And so therefore, you want the judge to assess the punishment in your case. We call that an unagreed plea bargain agreement. So just to recap, you have a right to have an attorney. You can either request time to hire an attorney, you can apply for a court-appointed attorney, or you can waive your right to an attorney to represent yourself. You have a right to have a trial by jury, or you can waive your right to have a trial by jury, and your case will come before the judge in one of three ways: by a bench trial, by an agreed plea bargain agreement, or by an unagreed plea bargain agreement. The other right that you have is a right to have witnesses to come to court to testify in your case. Now, witnesses can testify either for you or against you. And we call that either direct examination or cross-examination, because you can ask them, if you're representing yourself, you can ask them questions, or if you have an attorney, your attorney can ask them questions. And we call that either direct examination or cross-examination. You also have a right to waive or give up your right to have witnesses to come to court. Now, if you waive your right to have witnesses to come to court, that simply means that you will not be calling witness. It does not mean that the state will not be calling witnesses, because the state will be calling witnesses in the case that they have against you. Now, you also have a Fifth Amendment right against self-incrimination. And what that means is you have a right not to testify in your case. And the state of Texas, the DA's office cannot force you to testify in your case. In essence, they cannot call you as a witness in your case if you have taken the Fifth Amendment right against self-incrimination. Now, you can waive or give up your Fifth Amendment right against self-incrimination. And by doing so, you will be taking a stand to testify in your case. The other right that you have is a right to have discovery. And what discovery is, you have a right to see the evidence that the state has against you. You have a right to review the documents. You have a right to have access to the instruments. They'll review videos, audio recordings, witness statements. Now, you have a right to have access to that. They're not required to give you a copy of it. Now, your attorney can get copies, but your attorney is not allowed, pursuant to Article 39.14, he's not allowed to give you copies of that discovery as well. Now, everyone that's here today for arraignment, you have been arrested. And every day, and that just simply means that you're out of jail, either on a bond. It could either be a cash bond, which means that you paid the full amount of the bond to get out of jail, or you're out on a surety bond, which means that you pay the bondsman a percentage of the bond to get out of jail, or you're either out on a PR or a personal recognizance bond, which means that you did not have to pay any money to get out of jail. You were released under your own personal recognizance. Now, every day that you spent in jail, that jail time could be used as credit toward your punishment. So, for example, let's say you and the state have reached an agreement to settle your case. The state is offering you 5 days in jail, and you've accepted the 5 days in jail. If you already spent 5 days in jail, you won't have to spend any more time in jail because you'll be given credit for the time that you've already served. So therefore, you'll be given credit for time served. So you will not have to serve any more time in jail. If the state is offering a fine and court costs, and let's say the fine and court costs that the state is offering is $500. Now, let's say you spent 5 days in jail. Every day that you spent in jail, you get credit at $100 per day that will go towards your fine and court costs. So 5 days in jail is $500. State is offering you $500 fine and court costs. That simply means that you would not be required to pay the fine and court costs. Why? Because the time that you spent in jail has already paid it off. Therefore, it will be taxed and retired. Now, Jefferson County has a program for first-time offenders. It's called pretrial diversion. With the pretrial diversion program, what they will do, the district attorney's office, they will dismiss your case. And when you successfully complete the program, you can get the case expunged from your record. Expunged means erased, deleted, or wiped off from your criminal record. Now, in order to qualify for the program, as I mentioned earlier, you have to be a first-time offender. You have to have an attorney to assist you at doing the paperwork, and it cannot be an offense for evading arrest or unlawfully carrying a weapon. If you're a veteran of any one of the branches of the United States military, the district attorney's office also has another program where they would dismiss the case, and when you complete the case, you can get it expunged from your record. That program is called Veterans Court. It's for veterans only. If you're a veteran and you like to see if you qualify for that program, we have, I think there's an application here, or we can get an application from the district attorney's office for you and your attorney to fill out, and you can submit the letter requesting admission into the Veterans Court program. Okay, now this court has a program that is called the CSI program, stands for Community Safety Initiative. CSI program is a program that was started in March of 2017, within 100 days of taking office. That program is designed to make Jefferson County a safer place for all of us to live, work, go to school, raise our children, and to go to church. The way the program operates is we have a partnership with local agencies. One of the agencies that we have a partnership with is Spindletop. Now, the young people that I introduced to you earlier, they're from Spindletop. They're going to come to you in a little bit and tell you something about the Spindletop program. But basically, when the program was started, the program was designed where individuals can get a private interview, an assessment can be performed, and Spindletop has ability to develop a treatment plan, either outpatient or inpatient treatment. Spindletop also has a program, it's a drug treatment and alcohol treatment program. It's called ATAR. Our local drug and alcohol counselor has another program similar to that. It's called OZAR. Both of those programs are designed where individuals will be interviewed. In essence, they'll be given a screening, an assessment, and they can be referred for either outpatient or inpatient treatment. If you are unemployed and do not have a job, we have a partnership with the Golden Triangle Employment. We have a partnership with Golden Triangle and the Golden Triangle program, they have a partnership with Lamar University. Lamar University has a program that is called CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training program and a job placement program. Individuals are trained in the hotel industry, the shipping industry, or the chemical industry. Once they're trained in one of those areas that they select, then CICE will assist them at getting a job in the area that they're trained in. If you have not graduated from high school, CICE also has a GED program where you could get your graduate equivalency diploma. All of these programs that I just mentioned are free. It does not cost you anything. Only thing I guess it will cost you just your time. And speaking of time, in this court, we do not just give time, we take our time. We do not just arrest the problem, we address the problem. And we believe that if we address the problem, we can produce productive people. And we believe that productive people will not commit crimes. Why? Because they have too much to lose. And so in this court, we don't have court as usual. We have unusual court. It's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that comes before this court. And we're also trying to make a difference in the community in which we live by producing productive people and by making Jefferson County a safer place for all of us. Now, I mentioned to you that folks from Spindletop is going to come forward. We have Deputy Hinton and we have Gabrielle Leggington, who is going to come forth and they're going to tell you something about the program that Spindletop has to offer.
Thank you, Your Honor.
You're welcome.
Good morning. My name is Steve Hinton. I'm a mental health deputy licensed by the state of Texas. I'm here with my partner, Gabby. Gabby is a qualified mental health professional with Spindletop. The reason we are both here this morning is the judge has graciously invited us to the courtroom because he cares about every single person who comes before the bench. What the judge found, and what statistics prove, is those who have legal issues probably have mental health needs, substance use disorders, but sometimes just a lack of community resources. Judge believes if he can help with these underlying issues, he can get you out of the cycle of progress. This program has the ability to change your life if you'll participate, but we're going to need something from you. What we're going to need is for you to share what you with us. And Gabby's going to explain to you on that document we hand out when you first come in, how you can share that need with us very privately.
So this serves as a baseline significance, and also that means none of this is protected, just like any of your medical records. Doesn't go anywhere except for science. And so this allows us to contact you once and only once. If you'd like to keep in contact with us, then you can tell us not to do that. But this just gives us the opportunity to talk to you and just to see what you need. It can be work related, medically related. It can be a lot of stuff, not just mental health. So we can help you on a lot of scales, but we need you to just let us know one. And also, one of my other coworkers is in the back. If you would like to talk to someone today, if you're feeling a little anxious or you just would like to get to know us a little more or know about our program, we can bring you in the back and we can talk to you. It won't interrupt your court day or add on to your time here. So.
So before you leave here today, I have a flyer for you. I want to get in your hands. On the back, it tells you a little bit about the advantages of the program, but on the front, it also has the 1-800 number. Should you ever find yourself in an unsafe place, you can get help immediately by calling the number. Now, shortly, the court's going to go into recess. When it does, we will come by and pick up those documents from you. We'll be able to visit with you personally and speak to you privately if that's something that you see a value in and you wish to do that today. And I'm also be able to get. Thank you, Your Honor.
Okay, thank you, Deputy Hinton and Gabby. Ladies and gentlemen, the paperwork that you have in your hand if you need some assistance to fill that paperwork out, we have our court personnel who's here, who will be, who coming by to assist you at filling out the paperwork. Now, it's gonna take us a few minutes to get through the paperwork that you have. And so while we are organizing the paperwork and going through the paperwork, if you need to use the restroom, there are 2 restrooms right outside the courtroom. The men's restroom is to the right in front of County Court at Law number 3, and the women's restroom is on the other side of the hall in front of the 172nd District Court. So at this time, the court is going to go into recess so that our court personnel can assist at helping you fill out your paperwork, and also our court personnel will be picking up that paperwork. So at this time, the court will be in recess.